I'm Roberto Corrada, a professor at the University of Denver Sturm College of Law.
Website.
Well, we're talking about my labor law class, and I teach that class as a simulation. Very quickly, a simulation where I allow the students to organize and form a union in the class if they want to. I started teaching that way probably about 16 or 17 years ago. And I thought, well, the classroom is a lot like the workplace. The professor's like the boss. The professor tells you what to do, and your compensation is grades. And so I thought I would teach the class in that way and allow them to organize as students, but that the analogy would work to allow them to understand the cases better. And I started doing that, and it seemed to work. My class is different from a traditional labor law class in that in the traditional law school doctrinal course, the students read cases, and then they'll have the assignments. They'll come to class prepared to recite the cases, and then the professor will ask them questions about the cases. In my class, we do also learn the cases. We do use the case method, but they also have to go about the task of figuring out whether they're going to organize a union or not. If they decide they're going to organize the union, they have to do that. Of course, they have to follow all the cases, so they have to apply the law in the simulation class, and that's where they really learn it quite well. Because it has stakes. It's important to them in terms of the simulation, and if they're going to form a union, they need to know how to go about doing that in the way that the law requires. And so then they do that, and if they form the union, then we go to collective bargaining, and they learn how to the collective bargaining law in the cases. But then, as we conduct collective bargaining and develop an agreement, they can also see it at work. So they're not only getting the analytical skills, but they're also developing expert practice in the area. They're filing unfair labor practice charges, they're negotiating, and they're drafting collective bargaining agreements in the class. I was inspired to start teaching my classes this way, both because there was a need. As I said, the students didn't seem to have a union background, or even a cousin or aunt or grandfather who was in a union. And a lot of them didn't even have any work experience. And the case law in the cases was hard to sort of understand contextually if you didn't have that background. And then I read an article by a friend of mine who's a professor at BYU. He had done something with groups in an employment discrimination class where he'd put the students into different groups. And then it occurred to me, well, maybe I can allow the students to organize or something. And then I realized there's an analogy between the classroom and the workplace. And so then I just decided to go for it, and I started a long time ago now teaching this way. What I would tell a professor who's maybe on the fence is, number one, I totally understand that, because the first time you do anything, you're going to feel a little insecure. In fact, the first time you ever taught a class in the regular style, you probably weren't quite sure how you were going to go about it, and for the first couple of years, I would assume, if you're like me, you were going to be very uncertain and not sure what you were going to do. Well, it's the same thing with this type of teaching. At first, it's going to be very uncomfortable, and by the way, you have to make up your own mind. You may teach this way for a semester or two, and then decide this is not for you. I think most of the people who do try this end up sticking with it, and I think that's because they can palpably see the benefits to students, and they, I think, also can see that they're much more fulfilled as professors, that they're engaged with the class much more, and they're engaged with the students. And I love the fact that the students push me on particular areas that I don't know about, because then I get to go discover the law in that area in a way that I wouldn't in the regular, traditional type of class. So I understand the fear, but again, you have to start to become good at something. And I've often told people it's like driving stick shift. You learn to drive automatic, and then it's kind of daunting. You know how to drive. It's daunting to think about figuring out manual. But the only way to do it is to actually do it a couple of times, and then you develop from there. And it's the same way with these classes. At the very beginning, it's going to be kind of tricky. You're not going to know some of the techniques, how to work effectively with groups, but trust me, that all gets developed, and you figure it out. There's a benefit to the students who would go and work for larger firms. They're simply going to be able to hit the ground running much better. I imagine that they would be much more effective professionals and attorneys from day one if they have a lot of experiences like these simulation experiences coming out of law school. But the benefit is even greater for those students who are going to go out and hang up a shingle and be solo practitioners. And I think law practice is changing. I think there's going to be more of that going on. Clients and law firms are less willing to train students to become attorneys. And if that's the case, then law schools need to simply step up to the plate and have the students graduate in a better position to be attorneys, not just pass the bar exam. Our project is important, I think, at bottom because it is an application of the Carnegie Report. So Carnegie identified these 3 apprenticeships, and then they made recommendations. Their recommendation, bottom line recommendation, is that we think these 3 apprenticeships should be more integrated in law school learning. The classes we're talking about are classes, as I mentioned before, that have these apprenticeships sort of blended in. And so the question after the Carnegie Report is, geez, what does that look like? We are answering that question. We are answering what it looks like to have law learning taking place in the kind of integrated context that Carnegie was talking about.